In the High Court of Malawi, Principal Registrar, my lady, this is criminal case number 7 of 2020, the Republic versus Dr. Thompson Mpinganjira. The matter is called for judgment, my lady.
Thank you. Good morning, Councillor Ba. The accused, can you stand up? Is this on? So in this court, we don't have any public speaking. Okay. Can you hear me? Right. We are here for the judgment in the case where the accused person, Thompson Frank Mpinganjira, has been charged with 6 counts of offense under the Corrupt Practices Act. The charges arose surrounding the trial of the case of Dr. Saulos Klaus Chilima and Dr. Lazarus McCarthy Chakwera versus Professor Arthur Peter Mutharika and the Malawi Electoral Commission, which was the constitutional reference case number 1 of 2019, unreported. This case will be referred to as constitutional case reference number 1 of 2019 as we proceed into the judgment. The particular case was heard by a panel of 5 judges. The presidential election in the tripartite general election held on 19th May 2019 was challenged by the petitioners because of gross negligence, gross irregularities in the conduct of such election. The matter was brought to court and was subsequently certified as a constitutional case because the challenge had raised questions involving the interpretation of the Constitution. The court held or upheld the challenge, and the presidential result was nullified. The court ordered fresh presidential elections to be conducted. During the conduct of the trial, the constitutional reference case number 1 trial, it was exposed that the accused person had sought to influence the outcome of the constitutional reference case number 1 of 2019. It is alleged that he had offered substantial sums of money to 5 judges presiding over this case to decide the case in favor of the respondent. The accused person was arrested and charged with 6 counts of offense. The first count of offense is offering an advantage to a public officer contrary to Section 24, subsection 2 of the Corrupt Practices Act. The particulars of this count are that the accused person between 1st October 2019 and 30th November 2019 within the city of Blantyre offered an advantage, namely an unspecified amount of money to Justice Michael Atanasio Tembo for the benefit of the said Justice Atanasio Tembo and Justices Hili Potani, Ive Kamanga, Dingiswa Madise, and Justice Professor Reton Kapindu, all of which were public officers and members of the court panel sitting on the constitutional reference case number 1 of 2019. And it was given as an inducement for the 5 judges to decide the constitutional reference case number 1 of 2019 in favor of the respondents in the said case, who were Professor Arthur Peter Mutharika and the Malawi Electoral Commission. In the alternative, the state charged the second count, which is attempting to induce a public officer to perform functions corruptly, contrary to Section 25, subsection A, 25A, subsection 2 of the Corrupt Practices Act. The particulars of the offense are that the accused person, Thompson Mpinganjira, between 1st October 2019 and 30th November 2019, within the city of Blantyre attempted to induce Justice Michael Atanasio Tembo, a public officer and a member of the Constitutional Court panel sitting on the Constitutional Reference Case number 1 of 2019, to exercise or perform his functions corruptly in relation to the said Constitutional Reference Case, namely to accept an unspecified amount of money for himself and for Justices Hilly Potani, Ivy Kamanga, Dingiswayo Madise, and Professor Redson Kapindu, in order for the 5 judges to decide the said Constitutional Reference Case number 1 of 2019 in favor of the former President, Professor Peter Mutharika, and this Malawi Electoral Commission. Again, in the alternative to the second count, the third count is attempting to induce a public officer to abuse his public office contrary to Section 25B, subsection 2 of the Corrupt Practices Act. The particulars of the offense are that the accused person, Thompson Mpinganjira, between 1st October 2019 and 30th November 2019, within the city of Blantyre, attempted to induce Justice Michael Atanasio Tembo, a public officer and member of the Constitutional Court panel sitting on the Constitutional Reference Case number 1 of 2019, to abuse his public office or position as a member of the said Constitutional Court panel by offering him an unspecified amount of money for the advantage of the former, for the purposes of the panel making a decision for the advantage of the former President, Professor Peter Mutharika, and the Malawi Electoral Commission. The fourth count is offering an advantage to a public officer contrary to Section 24, subsection 2 of the Corrupt Practices Act. The particulars of the offense are that the accused person, Thompson Mpinganjira, between 1st October 2019 and 30th November 2019, within the city of Blantyre, offered an advantage, namely an unspecified amount of money, to Justice Hilly Potani for the benefit of the said Justice Hilly Potani and Justices Michael Atanasio Tembo, Ivy Kamanga, Dingiswayo Madise, and Professor Redson Kapindu, all being public officers and members of the Constitutional Court panel sitting on the Constitutional Reference Case number 1, as an inducement for the 5 judges to decide the Constitutional Reference Case number 1 of 2019 in favor of the former President, Professor Peter Mutharika, and Malawi Electoral Commission. In the alternative to the fourth count, the fifth count is attempting to induce a public officer to perform functions corruptly, contrary to Section 25A, subsection 2 of the Corrupt Practices Act. The particulars of the offense are that the accused person, Thompson Mpinganjira, between 1st October 2019 and 30th November 2019, within the city of Lilongwe, attempted to induce Justice Hilly Potani, a public officer and member of the Constitutional Court panel sitting on the Constitutional Reference Case number 1 of 2019, to exercise or perform his functions corruptly in relation to the said Constitutional Reference Case, namely to accept an unspecified amount of money for himself and for Justices Michael Atanasio Tembo, Ivy Kamanga, Dingiswayo Madise, and Professor Redson Kapindu, in order for the 5 judges to decide the said Constitutional Reference Case number 1 of 2019 in favor of the former President Peter Mutharika and Malawi Electoral Commission. In the alternative to the fifth count, the sixth count is attempting to induce a public officer to abuse his office contrary to Section 25B, subsection 2 of the Corrupt Practices Act. The particulars of the offense are that the accused person, Thompson Mpinganjira, between 1st October 2019 and 30th November 2019, within the city of Lilongwe, attempted to induce Justice Hilly Potani, a public officer and a member of the constitutional panel sitting on the constitutional reference case number 1 of 2019 to abuse his public office or position as a member of the said constitutional court by offering him an unspecified amount of money for the advantage of the former president for the purposes of deciding the case for the advantage of the former president, Professor Arthur Peter Mutharika, and the Malawi Electoral Commission. The accused person denied all the 6 counts of offense, and a plea of guilty was entered in respect of each one of the counts. Before trial began, the accused person made an application under Section 252A of the Criminal Procedure and Evidence Code to enter into a plea bargain process. The court allowed the process. At the end of the process, the defense and the state had made their positions known and the plea bargaining process had been concluded. However, the accused person had sought more time to make his own consultations before accepting or rejecting the state's offer. The court denied the application to extend the plea bargaining period because consultations were not necessary, as the bargain was between the accused person and the state, not any other third parties. The prosecution, therefore, started parading their witnesses. They called 6 witnesses. The first witness was Justice Michael Atanasio Tembo. He told the court that he is a judge of the High Court in the General Civil Division and that he sat as a member of the panel of judges hearing Constitutional Reference Case number 1 of 2019, together with Justices Kapindu, Madise, Kamanga, and Potani. He testified that the petitioners in the said case were Dr. Saulos Klaus Chilima and Dr. Lazarus Chakwera, and that the respondents were Arthur Peter Mutharika and of the Democratic Progressive Party and the Malawi Electoral Commission. Justice Tembo told the court that the issues which was before the election which was before that court, the Constitutional Court, was regarding the election of Arthur Peter Mutharika. The petitioners were arguing that he was not duly elected as a president due to the irregularities in the 2019 presidential election. Justice Tembo told the court that he personally knows the accused person as a person he goes to the same church with, the church being Sunnyside Seventh-day Adventist Church. He told the court that the accused person had contacted him 4 times in this particular issue. The first time on the 9th of October 2019, the second time on the 10th of October 2019, the third time on the 13th of October 2019, and the last time on the 30th of October 2019. Justice Tembo told the court that the accused person sent a message around 6 in the morning on 9th October 2019 asking for Justice Potani's phone number. At this moment, the accused person did not disclose to the witness why he wanted Justice Potani's number. The witness said he later shared this issue with Justice Kapindu and that he informed Justice Potani that the accused person was looking for him and for his number, and that the witness told Justice Potani about this information in the presence of Justice Madise and Justice Kapindu at Ufulu Gardens in Nirongwe. Justice Potani advised that his contact number could be given to the accused person. And this, the first witness for the prosecution did. The witness went on to tell the court that on 10th October at lunchtime, Justice Potani informed the whole group as we're having lunch together that he had bad news because he had received a call from the accused person who had told him that he was running a project of lawyers and judges, which project included Justice Chikopa, and that he was told, the accused person had been told to contact Justice Potani as the chair of the Constitutional Reference case panel and had been told to give Justice Potani a parcel. The accused person also told Justice Potani that he was ready to bring that particular parcel to Lilongwe, but Justice Potani told him that not to bring the parcel to Lilongwe, but instead give it to him in Blantyre. The witness further informed the court that on 13th of October 2019, the accused person texted him on WhatsApp and informed him that he had managed to get in touch with Justice Potani and that the accused person was happy to have gotten in touch with Justice Potani. The witness further told the court that on 24th October 2019, between 12 o'clock noon and 1 o'clock p.m., the accused person called him on WhatsApp, and the witness did not pick the call. He sent a text telling him that he would call the accused person back at 5 p.m. The witness told the court that the accused person then called him on his cell phone number in the evening and told him that Justice Potani was not available. The accused person also stated that the time was running out for him. The accused person further complained that Justice Potani just sent a text to him acknowledging his call, but he never returned the call and he never arranged to meet the accused person. When the witness asked the accused person what it is he wanted Justice Potani for, the accused person said to Justice Tembo that he thought Justice Tembo knew everything. However, the accused person then explained to Justice Tembo, the witness, about the discussion he had had with Justice Potani. The accused person explained that he told Justice Potani that he was running a project of judges and lawyers and that he was advised to talk to Justice Potani because there was a parcel to be given to Justice Potani. The accused person further stated that he is a lender, as a banker lending money, that he lends money to different people, including the Democratic Progressive Party officials, and that people he lends money to are supposed to pay him back. That as a lender, he finds out the purposes for which people have borrowed money from him. The witness informed the court that the accused person told him that he needed to know why he wanted Justice Potani because he was not the one who gave him justice. He was the one who gave him Justice Potani's number. The accused person told the witness that he had been given a parcel and that when he had opened it and looked inside, there was cash. He then said that he had been told to give it to Justice Potani. That the witness asked the accused person if Justice Potani knew that someone was sending him a parcel. And the accused person said yes, they had talked about it and Justice Potani knew. Whereupon the accused person stated that he was running out of time and he wanted Justice Tembo to carry the parcel to Justice Potani. And Justice Tembo refused to carry the parcel to Justice Potani. The witness, Justice Tembo, told this court that the accused person told him further that the money was meant to be given to Justice Potani and later the money would be shared amongst the 5 judges. The accused person stated that they were concerned, him and whoever had sent him were concerned as to whether the money was reaching the judges. The mission of the accused person was to find out whether the money was reaching the judges. And he wanted to verify because he had questions that arose from the conduct of counsel for the lawyer representing Arthur Peter Mutharika in the Constitutional Reference Court, case number 1 of 2019, who had been receiving money and not sharing it with his colleagues. The accused person further told the witness that Counsel Mbeta was also receiving money. The witness told the court that the accused person informed him that his cousin, Brown Mpinganjira, advised him to ask Justice Tembo whether the money was being received because he was a fellow Seventh-day Adventist church member. Upon hearing this, the witness told the accused person that they were being scammed because no money was reaching the judges, and in any event, no money was reaching him as a witness in this case. The accused person later asked the witness again to help him with the project by taking the parcel of money to give to Justice Potani. The accused person further told the witness that the money that had been sent, or the money that he had seen, was in excess of 100 million Malawi Kwacha, and that everyone in the camp, his camp, whoever sent him, knew about the issue of money, including the principal. The witness also had the conversation with the accused person about the principal, who was, according to the witness, Arthur Peter Mutarika. And he was the first respondent in the constitutional case, reference case number 1 of 2019. The witness told the court that the accused person further said that some people had told him that the DPP officials were afraid because DPP officials thought that the petitioners in the election case, which were Dr. Lazarus Chakwera and Dr. Salos Chirima, were giving money to judges, and that the DPP officials even said, Mukapanda kupereka muzalira. The witness further told the court that on 13th of October 2019, the accused person told him that he had gone to the bottom of the matter and that he had confronted the person who was collecting money from him and later giving it to Justice Chikopa. The person insisted that the money was coming to the judges through Justice Potani. The accused person further added that Brown Mpinganjira told him that Justice Potani drove Justice Chikopa to Brown Mpinganjira'S residence. When asked by the witness whether he saw Justice Chikopa receiving money, the accused person indicated to the witness that he did not see Justice Chikopa receiving money. The witness informed the court that the accused person informed him that Justice Chikopa told Brown Mpinganjira that no amount of money could affect the decision of the judges in the constitutional reference case number 1 of 2019. And the witness told the court that he got the sense that Brown Mpinganjira was the one taking the money from the accused person to give to Justice Chikopa or failing to give to Justice Chikopa. The witness later told the court that he recorded the calls that that the accused person made to him and submitted the recordings as well as the printouts of his WhatsApp messages with the accused person to the ACB. The witness concluded his testimony by emphasizing that according to him, the accused person wanted to offer him and the judges a parcel containing money to induce or influence them to decide the election case, which is the constitutional reference case number 1 of 2019, in favor of the respondents. In cross-examination, the witness was asked to verify a number of issues in the transcript and the evidence he had given under oath, and this he did. He told the court that he has been a judge since the year 2013, and he knew the accused person since the year 2010 when he joined him when he joined the congregation at Sunnyside Seventh-day Adventist. Are those prescription glasses?
Yes.
But they shouldn't be shaded inside. You don't need them, put them off. He told the court, the witness told the court, that he sat in the seventh day in the Sabbath school together with the accused person, and they visited each other's homes, and that when he recorded the accused person's messages, the first recording of the 24th of October 2019 was done through a phone app automatically, and the one of the 30th of October 2019 was done through a loudspeaker and recording on his iPad. The witness informed the court that he recorded these particular conversations because he wanted to share with his colleagues as well as authorities in case of eventualities. The witness told the court that the matter was reported to the Chief Justice, who later reported to the Anti-Corruption Bureau, and it was a decision of the panel of judges not to report the matter immediately because of the sensitivity of the case that they were hearing and the national interest of the case. The witness was apprehensive at that time because there was so much being reported in social media as regards judges receiving bribes. The witness stated that he did not solicit information but just listened and asked for clarifications as the accused person talked to him. The witness was also aware that Justice Chikopa had been cleared, but he was not aware that the accused person had been cleared by the Anti-Corruption Bureau. The witness told the court that it was the accused person who had informed him that the money was in excess of 100 million Malai Kwacha. He also said that the accused person had informed him, the witness, that he had advised the people not to pay, but the people did not heed his advice. The accused person told the witness that it was him who contacted him and Justice Potani because Maere Anamugwera, which means the die had been cast and he had been chosen by those people, the third parties, which will come to later, to go and approach the judges. The second witness for the prosecution was Justice Hili Potani. He told the court that he was chairing a panel of judges in the Constitutional Reference Case number 1 of 2019, which involved Dr. Chilima and Dr. Chakwera as petitioners and Professor Arthur Peter Mutarika and the Malawi Electoral Commission as respondents. He narrated to the court that on 9th October 2019, Justice Tembo informed him that the accused person wanted his number. And that was done at Ufulu Gardens in the presence of two other judges, Justice Madise and Justice Kapindu. Justice Potani told the court that he told Justice Tembo to give the accused person his number, and that Justice Tembo should also give Justice Potani the number of the accused person so that when he calls, he should recognize the number. The witness further said that around 9:00 p.m. on 9th October 2019, the accused person called him. The accused person explained to Justice Potani that he was running a project with judges and lawyers, and he wanted to talk to Justice Potani as the chairperson of the panel of judges hearing the constitutional case reference number 1 of 2019. The witness told the court that he was apprehensive after hearing that the accused person wanted to talk to him as the chairperson of the panel of judges because he was handling a very sensitive case. The witness told the court that the accused person had told him that he had asked him if he had received parcels sent to him by the accused person through Justice Chikopa, and also that he wanted to be advised on how he should deliver another parcel that he had in his possession, and that he was ready to fly to Lilongwe from Blantyre to hand over the parcel. The witness told the accused person not to travel to Lilongwe, but that they would meet in Blantyre. The witness said the accused person kept calling him, but he decided not to pick any of his calls. The witness told the court that he never met the accused person and he never received the parcel from him. The witness tendered printouts and screenshots of his cell phone and WhatsApp contact with the accused person that was made on the 9th of October 2019 as part of his evidence. In cross-examination, he told the court that he joined the judiciary in 1989 as a resident magistrate, together apparently with senior counsel Nkono, and he served as a chief resident magistrate, as a deputy registrar, and as a registrar of the High Court and Supreme Court of Malawi. He was appointed judge of the High Court in the year 2003. He was appointed judge in charge in the year 2014, and his duties as a judge in charge included looking over the welfare of judges, supervising judges, and case management. He was not surprised that the accused person wanted to call him because he believed the accused person wanted to follow up on a case. The conversation with the accused person on 9 October 2019 lasted about 5 minutes. The witness did repeat and confirm most of the points he raised in examination in chief. He told the court that the witness statements do not contain all the information. He also said there was no discussion of money between him and the accused person. He also said that the constitutional reference case was heard by a number of judges and the level of bias was minimal. In re-examination, he just confirmed the information that he had already given. The third witness was Justice Dingiswayo Madise. He told the court that he was informed by Justice Tembo and Justice Potani that the accused person, he told the court that he is a judge of the High Court. He told the court that Justice Tembo told Justice Potani that the accused person was looking for his number and that Justice Potani told Justice Tembo to give the accused person his number. The witness, Justice Madise, was present when this information was said, together with Justice Kapindu. Later, Justice Potani informed them that the accused person was trying to get in touch with him to give him a parcel as chair of the panel for the benefit of all the 5 judges who were sitting on the constitutional reference case number 1 of 2019. The witness further explained that Justice Potani said that he needed to report the matter to the Chief Justice, who should in turn report the matter to the Director of the Anti-Corruption Bureau. He said that after they briefed the Chief Justice, on what had transpired between him, Justice Potani, and the accused person, as well as what had transpired between Justice Tembo and the accused person, the panel made a decision not to report the matter at that particular time because of the case that they were dealing with. They did not want to lose focus. Justice Madise said that he found the conduct of the accused person offensive because one does not go around bribing judges. In cross-examination, counsel for the accused person stated first that the evidence of Justice Madise was hearsay. The court proceeded to direct that he could be cross-examined on the issues that he had witnessed. The witness stated that he was not part of the conversation between the accused person and Justice Potani, nor the accused person and Justice Tembo. The witness also was aware that the matter was not reported because there were fears of losing focus on the case at hand. He also stated that as far as he knew, the parcel was never received and no judge received any money. The fourth witness was Justice Rayson Kapindu. He told the court that he is a judge of the High Court, a visiting professor at the University of Pretoria, and a part-time lecturer at Chancellor College, the University of Malawi. He further told the court that he was appointed judge of the High Court in July 2013. He told the court that he was one of the judges presiding over the Constitutional Reference Case number 1 of 2019. He told the court that Justice Michael Atanasia Tembo had told him in person that he had received a message from the accused person, and the accused person had been requesting the phone number for Justice Potani. The witness and Justice Tembo were wondering as to why the accused person wanted the number, but Justice Potani allowed that his number could be shared with the accused person. The witness said on that particular time, Justice Madise and himself were present when this was said. The following day at lunch, Justice Potani told all 5 judges that he got a call from the accused person, and that the accused person was running a project, and that the witness explained to the court that Justice Potani told them in person that the accused person had told him, as the chair of the panel hearing the case, that he had a parcel for him, and the parcel had to be delivered to Justice Potani. When asked what Justice Tembo had told him, the witness said Justice Tembo told him that the accused person explained to him he wanted to deliver a parcel to Justice Potani, and that later the accused person asked Justice Tembo to deliver the parcel to Justice Potani. The witness stated that he was not privy to the conversation between Justice Tembo and the accused person, nor was he privy to the conversation between Justice Potani and the accused person, but that he had heard and listened to the recorded conversations between between Justice Tembo and the accused person, and that he had recognized Justice Tembo's voice as well as that of the accused person. The witness emphasized that the other person in the audio recordings was the accused person himself, because he had listened to the accused person speaking on numerous occasions and he could identify the voice of the accused person. The witness also told the court that as a panel they had decided not to report to the ACB immediately, but to inform the Chief Justice and report the matter to the ACB later when the case had been heard. In cross-examination, counsel for the accused person stated that the testimony of this witness was also hearsay. Again, the court directed that the witness be cross-examined on the issues he had direct knowledge on. The witness then told the court that he had never interacted with the accused person, but knew of him through radio and television as a high-profile person. He also listened to the conversation that was recorded. The witness said it was not wrong for the accused person to ask for the judge's number. He said the conversation among the judges was about an attempt to bribe with a parcel. He acknowledged that bribery cases ought to be reported within 48 hours unless there is a probable cause not to do so. In this case, he concluded that the probable cause in this matter was to ensure that there were no distractions until the Constitutional Reference Case number 1 of 2019 had been heard. The fifth witness was Lady Justice Ivy Chata Kamanga. She told the court that she is currently Justice of Appeal but was then a High Court judge during the period at issue. She was one of the judges sitting on the panel of judges in the Constitutional Reference Case number 1 of 2019. And the parties in the case were Dr. Lazarus Chakwera and Dr. Salos Chirima as the petitioners, and Professor Arthur Peter Mutarika and the Malawi Electoral Commission as the respondents. She said the members of the panel had agreed that they would be briefing each other in case anything happened as regarding the case. That she was told during lunchtime on 10th October 2019 by Justice Potani that he had shocking news, that the accused person had called him and wanted to find out if he was receiving parcels, and that he wanted to pass another parcel to Justice Potani, which was meant for the judges handling the case, the constitutional reference case number 1 of 2019. The prosecution witness 5, Justice Ive Kamanga, said that Justice Potani showed them the WhatsApp message of the contact, and that the accused person had said that they would meet either at Justice Potani's house or his house when he's in Blantyre. The witness had an opportunity to listen to the audio recordings that were recorded, and she recognized the voice of the accused person and the voice of Justice Tembo. She had listened to the accused person on various television stations and various meetings and fora, and she was able to identify his voice in the audio that she listened to. The witness told the court that she could vouch for the truthfulness of the conversation between Justice Tembo and the accused person because she listened to the recorded conversation. The witness also concluded her evidence by telling the court that she can confirm that the delays, she can confirm that the accused person and Justice Tembo had a conversation which was recorded and she had listened to it. In cross-examination, the witness stated that she confirmed the truthfulness of the conversation because she listened to it herself. She also stated that reporting later than 48 hours to the Anti-Corruption Bureau did not rob the Anti-Corruption Bureau of their opportunity to investigate the matter. The witness said that it was not feasible to report within the time frame because of the sensitivities of the case and the high likelihood of mob justice bearing the national interest of the matter, and also as a panel they also needed to protect the accused person. The sixth prosecution witness was Dan Mponda, an investigator at the Anti-Corruption Bureau who has been working there for a period of 19 years. He told the court that he knew the accused person through the investigation. He said the allegation was based on the letter that the Chief Justice had wrote to the Director General of the Anti-Corruption Bureau that the Managing Director of FDH Bank, who is accused person, had contacted 5 judges through Justice Potani and Justice Tembo and asked if they had received money that he was sending them. He tendered the letter from the Chief Justice as part of his evidence. The witness told the court that the team of investigators from the Anti-Corruption Bureau comprised of Pacharo Nyirenda, Viliera Liwonde, Florence Piri, and himself. And as part of their investigations, they conducted interviews, they looked at documents, they listened to the audio recordings, and any other piece of evidence that came by. The team interviewed Justice Michael Tembo, Justice Kapindu, Justice Kamanga, Justice Madise, and Justice Potani. The team interviewed and recorded verbatim what they were informed of. Then the team invited the accused person to come in to be interviewed as well. The witness said that after analyzing the materials they had and all the information established by their investigation, they charged the accused person with the offenses outlined in the 6 counts. The witness told the court that the accused person was invited to their offices, first as a witness to give evidence, and later, when he was arrested, to give evidence under caution. In cross-examination, the witness stated that he joined the ACB in the year 2001, that he had a Bachelor of Education degree, and he trained locally and abroad as an investigator, and he holds a master's degree in strategic planning. He said the Chief Justice lodged the complaint through a letter dated 2nd December 2019, which his office received on 10 January 2020. The witness stated that the Corrupt Practices Act encourages early reporting so that evidence should not be lost and witnesses would have issues in their minds and the issues will still be fresh. There was no evidence that the judges were given money to decide in favor of the respondents. The witness also stated that in matters of corruption, offers and actions are not done directly. The accused was interviewed as a witness and later arrested and interviewed under caution. He said that if there had been any early reporting, they might have found the person. There was an investigation on Justice Chikopa, but he was cleared. He informed the court that the bank accounts of the accused person and Justice Chikopa were checked and there was no reflection of the movement of the sum of 100 million Malawi kwacha. In re-examination, he stated that the delays affect quality of investigation, but in this particular case, there was no negative effect on the investigation. When the accused person was being interviewed, his lawyer, Senior Counsel Nkono, asked for brief consultation, and afterwards, when the interview resumed, the accused person simply responded to all the questions put to him with a response, "No comment." The parcel was mentioned by the accused person and not by Justice Tembo. The witness also informed the court that any person can report corruption. At the close of the prosecution's case, the court made an assessment of the evidence to find out whether or not the prosecution had preferred sufficient evidence to warrant the accused person to enter his defense, as required by Section 303 of the Criminal Procedure and Evidence Code. The court found that the evidence of the prosecution raised a prima facie case against the accused person sufficient to put him on defense. The court informed the accused person that the call to enter a defense was not mandatory in view of Section 42, subsection 2, subsection F, subsection 3, Roman numeral 3 of the Constitution of the Republic of Malawi, as the accused person had the right to choose to defend himself or to exercise his right to remain silent. However, the court informed the accused person that whichever choice he makes, the court will be able to proceed with judgment based on the evidence before it. The accused person opted to enter his defense. Before entering his defense, the accused person made an application that this court should recuse itself on allegations of impropriety. He accused this court of receiving or intending to receive or having promised to receive a bribe which was solicited by a person called Tim Zambezi with the accused person, so that the decision of this court would be in favor of the accused person. This court refused to recuse itself, and the accused person appealed against the ruling of this court to the Supreme Court, and the decision of the Supreme Court was to dismiss that appeal. The accused person returned to this court to give evidence, and he intended to call 4 witnesses. However, only 2 witnesses testified. The accused person testified, but he also made an application before this court that he needed to be protected. and the court, he and his witnesses needed to be protected. The court granted an anonymity order and allowed the witnesses for the accused person to give evidence in camera due to the perceived threats to their lives. Regardless of the anonymity order and the guarantee for protection, the other two witnesses who had come to Blantyre from Lilongwe to testify did not testify in this court. The first defense witness was the accused person himself. He told the court that he resides in Nyambadwe at plot number NY628 in Blantyre, and that he comes from Zungu Village Traditional Authority Vumbwe in Tiolo District. He holds a bachelor's degree in accountancy and is a fellow of the Chartered Institute of Accountants and has been a fellow since 1992. He told the court that he is a business person, having retired from active employment as the Group Chief Executive Officer of FDH Holdings, a position he had held from the year 2007. The witness told the court that he was Managing Director of FDH Holdings Group from 2002 to 2007. He told the court that he founded the company in the year 2000, that the process of establishing the company started in the year 1919, but that it was but that the company started its operations in the year 2002. The witness, the accused person, stated that he holds shares in the FDH Holdings Group through his company Continental Development Limited. He told the court that he does not hold any position in the Mulakoa Lomwe cultural grouping, and he is not a member of any political party in Malawi. He told the court that he did not have any preference on who would win the constitutional reference case number 1 of 2019. He indicated that he knows Arthur Peter Mutarika, who belongs to the Democratic Progressive Party. He also told the court that he supports all political parties that go to him for assistance, and that he funds all political parties the same way as he funds other projects in the country. He told the court that he has never had any ambition to take any leadership position in any political parties, and that he is aware that social media thinks that he is interested in a position in the Democratic Progressive Party. He told the court that he has addressed this issue in the media briefings and conferences on a number of occasions. The witness told the court that he assisted political parties such as the People's Party, the United Transformation Party, UTM, and the Malawi Congress Party, MCP. That he has personally dealt with leaders of these political parties and also Professor Arthur Peter Mutarika. The witness told the court that he has ever been linked with the leadership of DPP, but he has no ambitions to contest. The witness told the court that late Paramount Chief Ngolongoliwa once approached him in March 2018 to ask if he could be a running mate for the presidential candidate for the Democratic Progressive Party. But he had told the chief that he was not interested because he was a business person. He also told the court that on 24th September 2019, Prince Kapondam Gaga, who is the current officer in charge of the state residence, approached him and asked if he would be a running mate to Dr. Lazarus Chakwera of the MCP in respect of the 2020 elections. And again, the accused person declined, stating that he is a business person and he is not interested in politics. With respect to the prosecution witness number 1, was Justice Tembo. This witness, the accused person, Thompson Mpinganjira, told the court that it is correct that he knows Justice Tembo, that he knew him in 2010, that they were together in the English class number 2 at their church, and that the class has 12 members, and that they also attend the same Sabbath school where they discuss things. He told the court that they visit each other as members as well as members of the class, and they have visited each other when there is a social need, for example, a bereavement as well as the birth of a child. The witness told the court that he remembers Justice Tembo saying that he did not consider him as a friend in court, and this surprised him because when a person converses with another on personal matters, then it means they're friends. He gave an example of a personal matter that Justice Tembo discussed with him, which was the allegation that Justice Tembo had embezzled 20 million Malawi kwacha in 2014. The witness told the court that Justice Tembo said that he had asked for the cell phone number of Justice Potani was true. He also told the court that what Justice Tembo had said, that Potani had called him, he had called Justice Potani, was also true. The witness told the court that he recalls the evidence concerning the audio recordings that he had with Justice Tembo. He told the court he did not know that Justice Tembo was recording the conversation that they were having, and he was made aware of the recordings when he went to the Anti-Corruption Bureau. He recalls that the recordings were played in his presence, and he recognized the people speaking in the audio recordings as being himself and Justice Tembo. The witness told the court that he could not dispute the authenticity of the recordings played in court, and indeed agreed that he had that conversation with Justice Tembo, and therefore he had no problems with the recordings and their content. The witness, however, told the court that he was surprised that Justice Tembo decided to record him instead of just telling him what he was doing wrong, because of the status of their relationship. With respect to the transcripts tendered in court, the witness confirmed that Speaker 1 referred to Justice Tembo and Speaker 2 referred to himself. He further told the court that he had a discussion with Justice Tembo about a parcel to be passed to Justice Potani, but he wasn't certain how much money was in that parcel, but the money was more than Malawi kwacha 100 million. The witness told the court that he did not meet Justice Potani, but only had a phone conversation with him. That the phone conversation with Justice Potani was very brief and lasted for not more than 5 minutes. The witness also told the court that he mentioned the parcel in the conversation with Justice Potani, but that he did not tell Justice Potani what was in the parcel and the purpose of the parcel. However, the witness told the court that, in fact, there was no parcel at all, but the reason he mentioned the parcel was that he thought that Justice Potani would grant him audience if he mentions a parcel. The witness wanted to meet Justice Potani because of the conversation he had heard that Justice Potani was receiving parcels. The witness, however, admitted in court that all he had was hearsay evidence that Justice Chikopa was passing on money to Justice Potani. With respect to the receipt of money or bribes by the judges, the witness told the court that he had heard that some judges received bribes and others do not. With respect to the donations made to political parties and politicians, the witness told the court that he made a number of donations to Dr. Lazarus Chakwera, that he donated a sum of 20 million on the 14th of February 2019, and that Bridget is the one who took the money to Dr. Lazarus Chakwera. The witness said that the request came from a Mr. Chivunde. The witness further told the court that Mr. Kaponda Mgaga made a request of 10 million, that further on 17 February 2019, 25 million was delivered at MCP headquarters. The witness told the court that a total of 98 million was delivered to Dr. Lazarus Chakwera. The money was both loans and donations. In relation to Dr. Saulos Chilima, the witness told the court that on 31st August 2018, he gave a loan of 50 million to Dr. Saulos Chilima, and that all was repaid except a balance of 3 million. That the payment was made in June 2019. That the payment he made in June 2019 was a donation and not a loan. On 3rd January 2020, he gave out another loan of 30 million to Dr. Chilima, and on 23rd March, the witness gave out a loan of 10 million. The witness further told the court that on 25th of October 2020, he provided a loan of 350 million kwacha to Dr. Chilima for purposes of purchasing Nissan vehicles for campaign. The witness indicated, however, that it was an FDH bank that provided the loan to Dr. Chilima. With respect to Joyce Banda, Dr. Joyce Banda, he told the court that he made a number of donations to Dr. Joyce Banda amounting to 40 million. The witness told the court that he had made a number of donations to Democratic Progressive Party, DPP, but he indicated that he had never gave money to the leader, Professor Arthur Mutarika, but that through his trust fund, which is called TFM Trust, he had borrowed money which he passed on to the DPP amounting to 945 million, and this amount of money remains unpaid back to him. In cross-examination, he told the court that the DPP, through Brown Mpinganjira, was giving money to Justice Chikopa, who then gave money to Justice Potani. Brown Mpinganjira got the money from the DPP, but the witness did not know the reasons for giving the money to Justice Potani. He also said the source that had accused judges of receiving bribes was Brown Mpinganjira himself. The witness insisted that there was no parcel, and he mentioned the parcel to secure an audience with Justice Potani. The witness conceded that he had no evidence in court as regards whether the money was requested by or received by Dr. Lazarus Chakwera, because he dealt with third parties. For Dr. Chakwera, Dr. Chilima, and Dr. Banda, the witness said that the money he gave to them was his own personal money. But for the Democratic Progressive Party, he borrowed the money as TFM Trust and paid the money to DPP. He did not charge interest, but just passed on what he got from the TFM Trust. The witness stated that it was not illegal for an institution that is not registered to lend money to actually do lend money. He also said that there was no evidence of how money was requested on Dr. Chakwera, and he considered that the evidence he gave would be hearsay. The witness considered that the issues of donations had nothing to do with the case at hand. He also said that this discussion on 100 million kwacha, the alleged receipt of judges and lawyers received bribes, were all based on what he heard from DPP. He also acknowledged that he worked with the party in power, and that at that particular time, it was the DPP that was in power. The witness also said that he had more positions under the DPP, and that he was more associated with the DPP Mlakowa Lomwe, to which late Paramount Chief Ngolongoliwa was a patron, who had asked him to be a running mate of DPP. The witness also confirmed the information in the transcript. He stated that he had retired from active work, and he had so retired, and his retirement was related to this particular case. In re-examination, he basically repeated most of what he had said in examination in chief. The second witness for the defense is Emily Piri, not her real name. The witness told the court that she works at FDH Bank and that she is related to the accused person. In summary, the witness told the court that she had on different occasions delivered money to Dr. Chilima and Dr. Lazarus Chakwera, With respect to Dr. Chilima, the witness told the court that she had delivered a total of 40 million to Dr. Chilima, 30 million delivered at his house in Area 10 on 3rd January 2020, and 10 million collected on 18 June 2020 by Mpatso, the driver, to Dr. Chilima. The witness also stated that she collected money back from Dr. Chilima amounting to 40 million, which had been given as a loan. This witness informed the court that her client, Dr. Thompson Mpinganjira, was the one who was sending her to go and give money to these particular persons. With respect to Dr. Chakwera, the witness told the court that on 14 February 2019, she met Dr. Chakwera at Ufulu Gardens and delivered 20 million kwacha. She had received the money from her client, the accused person. She also met Dr. Chakwera in his office at the MCP headquarters in Nilongwe in August 2019 and delivered 5 million. On 29th March 2020, she delivered 31 million cash to Chris Chaimabanda for paying of MCP monitors. And she had gotten the instructions to so deliver the money from her client, the accused person. In cross-examination, she considered that her testimony of telling the court the transaction between the accused person and Dr. Chilima and the transactions between the accused person and Dr. Chakwera, and that had nothing to do with the case at hand. She was aware that the accused person was being accused of bribery, but she was not giving evidence to show that the accused person as a banker took sides on the political front. She stated that she does transact on behalf of her client, the accused person, as a personal banker. She deals with CEOs, ministers, and other high-profile people. She said the process was not meant to avoid money laundering charges. The money she delivered could be loans or donations. She also stated she had no evidence of personal dealings in terms of handing over money to Dr. Chakwera. That was the evidence in this court. Now, the law under which the accused person is charged is the Corrupt Practices Act. It is incumbent on the state to prove a case, a criminal case, beyond reasonable doubt. And this is stated in section 183 of the Criminal Procedure and Evidence Code. The standard of proof, 187. The standard of proof in criminal cases is proof beyond reasonable doubt. And this proof can be brought by direct evidence as well as circumstantial evidence. The burden of proving the case is never on the accused person. However, the court listens to the evidence of the accused person in order to verify the veracity of that particular evidence, so that the court may conclude that it is probably true that the accused person did so and so. But it's never for the accused person to prove the case. Whenever there is any doubt in any evidence, that doubt has to be exercised in favor of the accused person. And the accused person has been charged under Section 24(2) of the Corrupt Practices Act, which states that any person who by himself or by or in conjunction with another person corruptly gives, promises, or offers any advantage to any public officer, whether for the benefit of that public officer or of any other officer, as an inducement or reward for doing or forbearing to do anything in relation to a matter or transaction, actual or proposed, with which any public body is or may be concerned, shall be guilty of an offense. The accused person here is being charged and accused of offering an advantage to the public officers. Section 25A, subsection 2 of the Corrupt Practices Act provides as follows: any person who uses his influence on or induces or persuades a public officer concerned with any matter or transaction falling within or connected to that public officer's jurisdiction, powers, duties, or functions to exercise or perform his powers, duties, functions corruptly, or otherwise to act corruptly in relation to such matter or transaction, shall be guilty of an offense. The accused person herein is accused of using his influence and attempting to persuade a public officer to perform his powers, duties, or functions corruptly. Section 25B, subsection 2 of the Corrupt Practices Act provides: any person who uses his influence on or induces or persuades a public officer to use, misuse, or abuse his public office or his position, status, or authority as a public officer for such person's advantage or for the advantage of another person, or to obtain directly or indirectly for such person or for another person any advantage, wealth, property, profit, or business interest, shall be guilty of an offense. Herein, the accused person is being accused of inducing, attempting to induce or to persuade the public officers to misuse or abuse the public office in ensuring that they make a decision in favor of the respondents, and that inducement is being done by offering an advantage. Section 183, subsection 1 of the Criminal Procedure and Evidence Code goes to the fact of oral evidence. It states, subject to this section, any fact of which oral evidence may be given in any criminal proceedings may be admitted for the purposes of these proceedings by or on behalf of the prosecution or the accused person, and the admission of such fact under this section shall be conclusive evidence in those proceedings of the fact admitted. This goes to show that both the state and the defense gave their evidence, and that evidence for those facts which were admitted, they become part of this evidence without any doubt. The accused person in his evidence agrees and admitted and stated that he had no problem with the recordings that were given as evidence in this court. He had no problems with them. So those are all the evidence contained in those transcripts of the audio recordings are admitted evidence before this court. Section 212 of the Criminal Procedure and Evidence Code provides that there is no required number of witnesses to prove a case, except where the law provides a limit. This means that each one of these parties could have called so many witnesses, and they did so. And it doesn't matter how many witnesses you call, as long as they're called and they provide their evidence before the court of law under oath and in accordance to the law. Section 232 of the Criminal Procedure and Evidence Code goes to deal with corroborative evidence. It states, when a witness whom it is intended to corroborate evidence gives evidence of any relevant fact, he may be questioned as to any other circumstances which he observed at or near to the time or place at which such relevant fact occurred. If the court is of the opinion that such circumstances, if proved, would corroborate the testimony of the witness as to the relevant fact which he testifies. Subsection 2 said evidence of a statement made at the time when or shortly before or shortly after an offense is alleged to have been committed and directly relating to a relevant fact in the case is admissible if it was made by a person who is a witness and if such statement is used for showing its consistency with the evidence. In this case, the principal witnesses for the prosecution were Justice Tembo and Justice Potan. But Justices Kamanga, Madise, Kapindu, I missed somebody, and Justice Dingiswa Madise, Justice Kamanga, Justice Kapindu, they were also witnesses who witnessed and observed at the time relevant facts that pertained to this matter at hand. And therefore, their evidence in as far as it relates to those relevant matters is admissible in this court. Again, the evidence of what they said, as long as it shows consistency with the statements that were given, would also be admissible in this court. These particular laws applies both to the accused person and his evidence, as well as to the prosecution as his evidence. In the case of Tambala versus Republic, a 1998 case reported in the Malawi Law Reports at page 391, the High Court dealt with corroboration with approval and cited the dictum of Bort J., who explained the legal expression corroboration. He stated, as the subject of corroboration appears to be one which perplexes and confuses many magistrates, it may be helpful to restate the position. As a matter of law, corroboration is not required except in cases of perjury or treason, and a court may convict on the evidence of a single witness. It stands to reason, however, that a case will normally be stronger if there are two or more witnesses who testify to the same state of affairs. Nevertheless, although as a matter of law corroboration is not required, there are certain types of cases in which, as a matter of practice, it is incumbent upon a trial court to consider whether any corroborative evidence exists. I refer now to sexual cases and to cases in which the evidence against the prisoner depends entirely or substantially on the word of an accomplice, a person who himself participated in some way in the alleged crime. In those two instances, it is considered not so much to be a matter of law, but rather a combination of caution, prudence, and common sense. In cases that has to do with corrupt practices, the actions are between the one, the corrupter, and the second, the corruptee, or the person who the corrupter intends to corrupt. In such situation, a court can convict based on the evidence of the person who has complained. But it does not hurt if there is other evidence that corroborates the evidence of the person who has reported the corruption. So in this case, this court would look at the evidence of Justice Tembo and all the other judges, as well as the evidence of the accused person and his witness, and the transcripts that were tendered into court. In the case of Kagwa versus Republic, a 1991 case reported in 14 Malawi Report, page 138, the court held that corroboration is nothing more than some additional evidence from a source which is independent of the evidence of the witness whose evidence requires corroboration. So all of this evidence would be considered either in its own strength or as an addition to the other evidence that would have been tendered by either the prosecution or the accused person. Where there is no direct evidence, the prosecution can prove a case beyond reasonable doubt through circumstantial evidence. It was held in the case of Regina versus Taylor that circumstantial evidence is very often the best evidence. It is evidence of circumstances which, by intensified examination, is capable of proving a proposition with the accuracy of mathematics. It is no derogation of evidence to say that it is circumstantial. In the case of the Director of Public Prosecution versus Kilburn, it was said that circumstantial evidence works by cumulatively in geometric progression, eliminating other possibilities. It is a combination of circumstances, none of which would raise a reasonable conviction or more than a mere suspicion, but taken together may create a strong conclusion of guilt, that is, with as much certainty as human affairs can require or admit. In the case of Via versus Republic, it was held that we must point out that the law regarding circumstantial evidence in our criminal jurisdiction, that is in Malawi, is now well settled as evidenced by numerous cases. Shortly stated, that law is as follows. Where the evidence is circumstantial and is accepted and gives a logical approach, is by way of eliminating that which is negativating all possible hypothesis of innocence. In order to justify from circumstantial evidence an inference of guilt, the facts must be incompatible with the innocence of the accused person, or incapable of explanation upon any other reasonable hypothesis other than the guilt of the accused person. A court of law only convicts a person if one inference and one inference only is possible. Where several inferences are open, some consistent with innocence, others consistent with guilt, it is not open to a court of law, in the absence of any evidence, to choose the inference consistent with guilt and to reject an inference consistent with innocence. There has been discussion on the issue of attempts. The general law on attempts, as covered by Section 35 of the Corrupt Practices Act, states that any person who attempts to commit or who aids, abets, or counsels or conspires with any person to commit an offense under this act shall be guilty of committing that offense. The case of Chilunga versus Republic explained that what an attempt of an offense is, where the court stated, it is common ground that not all acts which are towards the commission of offense of a crime are to be regarded as attempts. Some acts may be too far removed from the commission of the offense to be regarded as an attempt to commit the crime. But just where the distinction is to be drawn between preliminary acts of preparation and acts which are near enough related to the crime to amount to attempts to commit, it is often a difficult and it is often a difficult question to determine. In Public versus Saini, the court held that to constitute an attempt in connection with the full offense, an attempt must immediately and not remotely be connected to the offense, and it must amount to more than mere preparation for the offense. The facts of the case were that the accused person went to his house and picked some pieces of wire. He was asked by his wife what he wanted to do with the wire, and he replied that he wanted to hang himself. The matter was reported to the police. The accused person was charged with attempted suicide. In quashing the conviction, the court stated, for an act to be considered an attempt, the act done must be immediately and not merely remotely connected to the commission of the offense. In other words, it must be something more than mere preparation for the commission of the offense. In the instant case, even by a stretch of human imagination, what the accused person did could not be said to be an act which immediately connected him to the commission of the offense of attempted suicide. There was only a preparation for the offense and was only remotely connected with it. I find, therefore, that the conviction was in bad faith. In this case, the court has to look at the actions of the accused person as regards the rest of the evidence that have been brought before this court to determine whether the attempts were more than mere preparation to commit the offense of offering an advantage to public officers. It was held in Mpinganjira versus Republic that when a person has been convicted of an offense, the principal offense, he does not need to be convicted of the attempt because he would have been convicted with the offense. However, if the person cannot be convicted on the principal offense, the court can convict on an attempted offense. Section 400 of the Penal Code also deals with attempts, and it states, when a person intending to commit an offense begins to put his intention into execution by means adapted to its fulfillment and manifests his intentions by some overt act but does not fulfill his intention to such an extent as to commit the offense, he is deemed to attempt to commit the offense. It is immaterial except so far as regards punishment, whether the offender does all that is necessary on his part for completing the commission of the offense, or whether the complete fulfillment of his intention is prevented by circumstances independent of his will, or whether he desists of his own motion from the further execution of his intention. Subsection 3, it is immaterial that by the reason of the circumstances not known to the offender, it is impossible to commit the offense. Whether the offense itself was actually committed depends on whether the accused person was able to control the situation by his own independent will, or it was by somebody else who was not privy to him, denies to have ever having corruptly offered an advantage to Justices Potani and Tembo in particular, or to the other judges who were members of the panel of the constitutional reference case. The accused person states that all he was doing was to go to Justice Potani and verify the reports that he heard in the social media that the judges of the constitutional reference case number 1 of 219 were receiving bribes. This court has to determine if the evidence before it shows that the offense was committed and was so committed beyond reasonable doubt and was so committed by the accused person. It is not disputed that Justice Potani, Justice Tembo, and the other judges were public officers and were High Court judges, and at that particular time they were approached by the accused person. They were hearing the constitutional reference case number 1 of 2019. The question, did the accused person corruptly offer them an advantage so that they decide this case in favor of the respondents? The evidence shows that after the accused person was given the phone number of Justice Potani by Justice Tembo, he contacted Justice Potani. The accused person does not dispute. Justice Potani confirms. He contacted him and told him, or asked him first, whether he was receiving parcels. But when Justice Potani said he was not, the accused person then said, okay, I have another parcel for you. Can I come and deliver it to Lilongwe? That is not disputed. At that particular time, the accused person did not discuss the content of the parcel with Justice Potani. Nor did he say that this particular parcel, I'm only mentioning it because I wanted to talk to you. The defense has argued extensively that the parcel did not exist, and that it was mentioned only in order to gain access to Justice Potani and to confirm that he was hearing and confirm what the accused person was hearing about the judges receiving bribes. It is true that no one saw this particular parcel except the accused person who mentioned the parcel. The state, therefore, has relied on the evidence of the circumstances which the court has analyzed to see whether there was indeed a parcel that existed at that particular time. To get to that point of finding out whether this particular parcel existed at a particular time, the court would look at the evidence in the transcribed audios. The defense, the accused person and his counsel, in their final submissions have asked this court to look at the trustworthy evidence, which is the evidence of the transcripts that are before the court. The defense has considered this to be the most trustworthy evidence of all the evidence that has been brought to court. Now, looking at those particular transcripts, the first transcript is about the accused person stating the background of why he desperately, and repeat, desperately needed to reach Justice Potani and to give Justice Potani a parcel, and why he desperately needed Justice Tembo, who he calls his fallback person, to take that parcel to Justice Potani before the judges returned to Lilongwe to continue hearing the case, the constitutional reference case number 1. What was so crucial about this particular parcel? Again, the answers will come from the same transcript. The accused person only mentions the parcel to Justice Potani after the judge had said that he had not received former parcels. So here, if the accused person had intended to mention the parcel just as a way of gaining audience with Justice Potani, he would not have offered to bring the parcel to Lilongwe, because he already had audience with Justice Potani. This is what the trustworthy evidence of the transcripts is saying. The conclusion is the parcel did exist. Now, again, the defense has argued that the money, which was excess of 100 million kwacha, was made in reference to the different sums of money that the third parties had told the accused person about. When you look at this transcript, you'd find out that when the accused person had asked Justice Tembo as a fallback person to take the parcel to Justice Potani, he had disclosed that the parcel, he had opened the parcel had money, and the money was in excess of 100 million kwacha. it was not Justice Potani, not Justice Tembo who came up with the 100 million. It was the accused person. And this is reflected in the trustworthy transcripts. As to the issue of the money being shared among the judges, again, in his attempt to persuade Justice Tembo, the fallback person, to take this particular parcel agently to Justice Potani, the accused person does mention that the money, which is in excess of 100 million Malai Kwacha, was meant to be shared amongst the judges. So it is not true that the parcel did not exist. The circumstances as presented by the trustworthy transcripts shows that it did exist. The issue of the accused person coming back to court and saying this parcel did not exist only came up in his evidence in defense. He could have availed this information right when he was being interviewed at the ACB. He did not. He chose to state no comment. The issue of the DPP being involved, the issue of the lawyers for the DPP being involved and receiving money and not sharing among themselves, the issue of the 100 million Malai Kwacha being shared among the judges was all introduced by the accused person, not by Justice Tembo, as the accused person would like this court to believe. The explanation by the accused person that he mentioned the parcel to gain audience is not supported by the evidence in the transcript. First, the accused person received the cell phone number of Justice Potani without even mentioning the parcel. Second, after mentioning the parcel and offering to bring it to Lilongwe, Justice Potani told the accused person to meet him in Blantyre. Yet, the accused person failed to secure this particular meeting with Justice Potani. So if the parcel was meant to gain audience, why did it fail to sustain that audience with Justice Potani when he came to Blantyre? Thirdly, the accused person admits that he called Justice Potani daily to try to secure this meeting. Regardless of having mentioned the parcel, he still failed. The accused person mentions the parcel to Justice Tembo and the contents of the same in the hope of getting Justice Tembo to take the parcel to Justice Potani and to ensure that the parcel was received before Justice Potani returned to Lilongwe for the continued hearing of the Constitutional Reference Case number 1 of 2019. Looking at these circumstances, this court concludes that the transcript number 1 in totality and together with the evidence before this court, the accused person corruptly offered an advantage to Justice Potani and Justice Tembo, who he calls his fallback person, of the unspecified sum of money contained in a parcel. The parcel did exist. The accused person also attempted to have this court believe that he was fact-finding, and indeed in transcript number 2, he was updating Justice Tembo on what he had found. One has to remember that in transcript number 1, the accused person was afraid at one point that Justice Potani, who had refused to meet him or contact him, had reported him to the Anti-Corruption Bureau. This was a real fear. He may have laughed it off in the transcript, but it was a fear. Looking at the matter as it relates to corruption and attempting to offer an advantage, coupled with the fear of being reported, this court, having read transcript number 2, concludes that the accused person instigated this particular final call to Justice Tembo to cover his base in case of eventualities. First, the accused person stated that he went to verify with the person who told him of the bribes, which person is Brown Mpinganjira, and then he saw Justice Potani dropping Justice Chikopa at Brown Mpinganjira'S house. and was informed that the two judges received bribes from the DPP through Brown Mpinganjira. This information was meant to disarm Justice Tembo, to make him believe that the accused person had good intentions. Second, the accused person tells Justice Tembo that it was known that he did not receive bribes. How then, one wonders, would the accused person contact Justice Tembo and wanted him to take a parcel of bribe money as a fallback person in the first place, when he himself knew that Justice Tembo does not take bribes? Third, the accused person told Justice Tembo that he wanted to inform him that Justice Chikopa had told him, Justice Chikopa had told the accused person through Brown Mpinganjira that it was impossible to bribe or pay for a bribe for a specific outcome in the constitutional reference case number 1 of 2019. Looking at all this court concludes that having failed on his mission, the accused person needed desperately to seek ways of reducing damages or any damage or any possible eventuality that would come, bearing in mind that he was afraid he had been reported to the Anti-Corruption Bureau, and also possibly by introducing the camaraderie to disarm the intentions of Justice Tembo or any intended act he would have taken to report the matter. The accused person has also argued that the word corruptly, which is one of the crucial elements in the offense of offering an advantage, is missing in the particulars of the offense. As shown from the evidence of the transcribed audio clips, which the accused person considers to be trustworthy, the whole issue taken together shows that the accused person did corruptly offer an advantage to Justice Potani and Justice Tembo. Again, as he was pleading to the counts of the offense, the law as read to him showed that he was being accused of corruptly offering an advantage to the judges and not voluntarily giving gifts and donations to leaders of political parties or substantive and unpaid loans to the Democratic Progressive Party. The evidence as a whole shows one explanation and one explanation only, that the purpose of the parcel was to corruptly offer an advantage to the judges in return for a favorable outcome of the constitutional reference case number 1 to the respondents. As regards the general law on attempts, the actions of the accused person in desperately seeking the contact numbers of Justice Potani, in offering the parcel, and in desperate trying to get the parcel to Lilongwe, and then in desperately trying to get the parcel to Justice Potani through Justice Tembo, stating that he was running out of time and he did not want to be like the others who had failed, shows that this was more than an attempt. This was taking the matter into execution. The only thing is that the parcel was never received by Justice Tembo or Justice Potani. He did all the actions to ensure that the intended person would receive this advantage. It only failed because it was beyond his control. The intended persons did not receive the offered advantage. The accused person, again, has presented himself as a person not affiliated or interested in any political party. While the evidence of the prosecution, while the prosecution is mandated by the law to prove a case against an accused person beyond reasonable doubt, this court does look at the evidence of the accused person to show the veracity in his own claims. The accused person does not deny mentioning the parcel. He does not deny mentioning that there was money. He does not deny discussing, in all these discussions he had with Justice Tembo and Justice Potani, Justice Tembo mostly, in all the recorded evidence about the propensity of the panel of judges to receiving bribes. He does not deny that the subject matter of these particular audio recordings was bribery, corruption. Now, in his own evidence, he has come back and said the password does not exist. And then he's also said that to show that he was partial, he was not partial to any political party, and that he was impartial, he supported all political parties. He has gone to a length of presenting to this court that he was not affiliated to the Democratic Progressive Party. In cross-examination, the accused person successfully showed the court that he was in fact affiliated with the Democratic Progressive Party as a political party, other than any other of the mentioned parties, which is the United Transformation Party, the Malawi Congress Party, and the People's Party. First, the accused person held more positions in the public bodies under the DPP. Further, he agrees, this agrees with the assertion by the accused person that he, as a person of business and a person with business interests, works with the government in power and no one else. At that time of the occurrence of this particular attempt to bribe judges or to offer an advantage to judges, or the occurrence of these 6 counts of offense, it was the Democratic Progressive Party that was in power, and it was the Democratic Progressive Party that the accused person was dealing with, together with his cousin or brother, and he did mention so in the transcripts. Second, in cross-examination, he stated that he was approached by the leadership of the DPP, which included late Paramount Chief Ngolongoliwa, who was also the patron of the Mlago Walomwe, and he was fully affiliated with DPP. The accused person also does not dispute that his brother or cousin, Brown Mpinganjira, is in the top leadership in the Democratic Progressive Party, and was the source of information that judges in the Constitutional Reference Case number 1, 2019, were receiving bribes from other political parties as well as the DPP itself. The accused person attempted to show that he was contacted by a Prince Kapondangaga of MCP, to ask whether he would be interested to be a running mate for Dr. Chakwera for the 2020 elections. It is not known what position this particular Prince Kapondangaga held, but as compared to the DPP, this was the patron, this was a top leader, late Ngolongoliwa, who made the approach, which is more genuine than the one that was made by Prince Kapondangaga of MCP. In the audio clips as transcribed, the accused stated that he was a person with interest. A look at the interest, especially as pertaining to the money that he gave as loans, it is clear that the accused person's interest would lie with the Democratic Progressive Party retaining power, because the Democratic Progressive Party owed him money in excess of 946 million. The accused person explained that he borrowed money through his TFM trust and he passed it on as a loan to the DPP. And as of June 2021, when he presented this evidence to court, he was owed by DPP in excess of 946 million kwacha. And this bill had been accumulated from August 2018 to May 2021. This huge sum of money remains unpaid, so the accused said. It is also clear that the accused person acted illegally in the way he lent this money to the Democratic Progressive Party, because TFM Trust, which is a separate legal entity from him, is not registered as a lending institution in this country. This conduct of the accused person in using the TFM Trust to lend money ought to be investigated and clarified, especially as regards to political party funding. When you look to the amounts given, the amounts of money allegedly given to the political party leaders, and here I stress political party leaders, because there is no evidence from the accused person in his way of showing that he was not partial to one particular party, that he funded the Malawi Congress Party. There is no evidence that he funded the United Transformation Party. There is no evidence that he funded the People's Party. His evidence is simply that he gave loans and donations to the leaders of these political parties. The accused person claims that he gave Dr. Joyce Banda of People's Party donations from May 2021 to March 2020, totaling 40 million Malawi kwacha. This pales in contrast to the 946 million that was given to DPP. As regards Dr. Chilima, he gave donations and loans from August 2018 to March 2020. His witness had indicated to this court that 40 million that had been given as a loan was repaid. He had also shown that most of the loans given to Dr. Chilima were paid. The accused person used his bank, FDH, to guarantee a loan as pertaining to the purchase of campaign vehicles. This amount of 350 Malawi kwacha was done legally through FDH Bank. And as such, the accused person cannot claim that he was funding the UTM. He cannot even bring that information and say that he was giving a gift of 350 million to Dr. Chilima, because this was a legal process done through the bank, not by him. The money in terms of donations allegedly given to Dr. Chakwera, amounting to 94 million from February 2019 to May 2020. However, in cross-examination, the accused person and his witness were not able to state or to give evidence to show that this money was directly requested for by, or directly received by, or directly given to Dr. Chakwera. The transactions were always between third parties. In conclusion, as pertaining to the issue of donations and gifts, the accused person and his witness confirmed to this court that the evidence had no bearing to the charges that the accused person is facing. This court then concludes that the evidence was meant first to support and lend credence to the accused person's claim and the narrative that he was in danger from Malawi Congress Party supporters. And second, just to embarrass people he had voluntarily given donations to, and also used his bank to lend money. This court concludes that the accused person was indeed partial to Democratic Progressive Party. Therefore, in the charges, the counts of offense as read, which state that he gave an inducement, an advantage to ensure that the judges made a decision in favor of the respondents, who were the leader of the Democratic Progressive Party and the Malawi Electoral Commission, were true. The accused person and his counsel sought to paint Justice Tembo as a culprit in this case. They claimed he entrapped the accused person by recording their conversation. They portrayed Justice Tembo as a less objective person in giving evidence, as a person laboring under confirmation bias, for seemingly pushing the matter when the intended contact person, Justice Potani, was not. They also labeled Justice Tembo for being a person making ill-conceived conclusions. Looking at the evidence in transcript 1, this court finds that firstly, it is the accused person who sought Justice Tembo at all times. The issue of entrapment does not arise because the accused person confirmed that he did have had the conversation and he had no problems with adopting the transcripts as the trustworthy evidence. So that cannot be opened again as being entrapment. Secondly, the accused person had asked Justice Tembo to ask him direct questions and then he would get answers. So when Justice Tembo was asking direct questions and the accused person was dodging answering those direct questions, it was not because Justice Tembo was being pushy, was being ill-conceived, was belaboring under confirmation bias. It was simply because he had been asked to ask direct questions and he would get answers. Thirdly, the accused person considered Justice Tembo as a fallback person, and as such, he pursued Justice Tembo. And naturally, Justice Tembo, who did not want to operate under any assumptions, wanted to understand the whole situation. This court does not find that Justice Tembo's evidence is conjecture, nor does this court find any confirmation bias as alleged by the accused person. What the evidence shows as a whole, it only shows one conclusion: that the accused person had the parcel, he had a discussion with Justice Tembo which he agreed and adopted the transcripts, and he had intended to offer an advantage to Justice Potani and Justice Tembo as a fallback person for the benefit of the members of the panel hearing the constitutional reference case. There is no other explanation when one looks at the evidence before this court. Each circumstance leads to the guilt of the accused person. To that extent, this court finds the accused person, Thompson Frank Mpinganjira, guilty as charged. Because the other counts, count 3, 4, 5, and 6 were offered in the alternative, the court finds the accused person guilty under count 1 and 2 for offering an advantage to Justice Potani and Justice Tembo, who were public officers, and for the benefit of that advantage to be shared amongst the judges, namely Justice Ivy Chatakamanga, Justice Dingiswa Madise, Justice Redson Kapindu, and had aimed in all this to induce the judges to make a decision in favor of the respondents. The accused person is hereby convicted accordingly. Right? The accused person has been operating under bail. Bail is revoked forthwith. He shall be remanded at Chichiri prison, waiting for his sentencing.
Since the judgment is not yet perfected, in the earlier part of the judgment, the court had made reference. The court had made reference to the issue of recusal and indicated that the appeal was dismissed. Probably, my lady, you may wish to review just that small part, because the appeal has not yet been heard. what was dismissed was an application to stay the proceedings pending appeal. I think the state can confirm on that point.
Thank you. Noted.
There's another matter. I don't know whether you'd wish to confirm on that point first, or we can proceed.
Councillor Matemba.
Thank you so much, my lady. We were not shared with a copy of the ruling which Justice Nzingamanda made, but our understanding was the applications that were made by the defense before the Supreme Court were dismissed in totality. So maybe we may have to rely on that record, the ruling, which unfortunately we do not have a copy of, but the fact remains that was dismissed. In our understanding, first they wanted to stay the criminal proceedings before you, my lady. Then they were also appealing against your refusal to grant them leave to appeal. Thank you so much, my lady.
Well, lady, I think it goes without saying that a single judge does not hear an appeal.
Shall we not argue that point?
Yeah.
It's not part of the judgment. It's not essential to the judgment. I'll make the amendment that you've said. That's about it.
Much obliged, my lady. My lady, we are ready with our plea in mitigation.
Proceed.
My lady, the defendant before you is a first offender. You may recall, my lady, that actually even in the testimony of the first and second witnesses in the matter, they did speak of such high regard that they have had for him hitherto. He is currently 60 years old, which speaks volumes in terms of his uprightness until the unfortunate events that have led up to his conviction. He's a family man with children and grandchildren who look up to him. And he is a widower. As a matter of social responsibility, my lady, he has built and supports a large number of churches. He pays school fees for disadvantaged students. And he helps a lot in hospitals and health institutions. He's the founder of the Thompson and Barbara Mpinganjira Foundation, which he funds and also solicits funds for. Among projects that are being funded by the foundation is a project called Chamaka, that's CHAMACA, which is a project dealing with cervical cancer. So it benefits a lot of women. They also help at Queen Elizabeth Central Hospital and all other central hospitals. They help the Adventist Health Services, the Malamulo Mission Hospital, and currently in the pipeline they're working on requests from the organization MAP, Malawi Against Physical Disabilities, and also with the Kamuzu University of Health and Sciences, and also on a COVID sensitization project. He's an investor and an entrepreneur. And by reason of his businesses, employs hundreds of people. And by reason of the conviction, if he were to be put in custodial confinement, such employees and their families are likely to suffer. In raising funds for the Thompson and Barbara Foundation, he does require to travel. And similarly for his businesses. And it is in view of all these facts, my lady, that your defendant humbly prays for a non-custodial sentence. Recently, your defendant has come out to save the oldest football club in the country, the Mighty Wanderers. And is sponsoring the team. And you may recall, my lady, as well, the fact that at some point we had to adjourn the hearing of the matter when your defendant had suffered from COVID. Ever since that time, his health has been compromised, and he has been in frequent need of medical attention. In making our plea, we wish to refer to Section 339 and Section 340 of the Criminal Procedure and Evidence Code, in particular, my lady, we make reference to subsection 1 of section 340. And my lady, may I read? It says, where a person is convicted by a court of an offense and no previous conviction is proved against him, he shall not be sentenced for that offense otherwise than under section 339 to undergo imprisonment, not being imprisonment to be undergone in default of payment of a reasonable fine, unless it appears to the court on good grounds, which shall be set out by the court in the record, that there is no other appropriate means of dealing with him. We wish to place emphasis on the mandatory nature of this particular provision, that for first offenders, the court must not sentence an accused to a custodial sentence unless there are good enough reasons. Your defendant has already demonstrated his abhorrence for corruption, as it is on record with reference to attempts that were made on him in the year August 2020 to solicit a bribe from him. He did rush to the police and to the Anti-Corruption Bureau. So as we speak, my lady, you are dealing with a defendant who has already demonstrated remorse of the unfortunate acts that have led up to his conviction. But you're also dealing with a man who has demonstrated that henceforth he shall not tolerate any corruption. It is important to point out that Section 339 of the Criminal Procedure and Evidence Code emphasizes that suspended sentences may be given in any case for any offense, so long as the sentence is not fixed by law. And with reference to counts 1 and 2, upon which the court has convicted the defendant, the sentences are not fixed by law. There is no minimum sentence that the law prescribes. As a matter of fact, initially when the Corrupt Practices Act was first enacted, it did contain minimum sentences, and those were abolished. And therefore, it is open to the court to sentence the defendant to a suspended sentence. We wish to finally state, my lady, that as a matter of fact, the arrest and conviction for a person of the defendant's caliber in itself is a huge punishment, as it were. It shall be met with sanctions. As a professional accountant, which are bound to affect the defendant adversely and significantly for the rest of his life. His reputation, business-wise, locally and internationally, has already been severely affected. And we repeat, my lady, that in view of his age as well, it would be undesirable to meet him with custodial sentence or any lengthy custodial sentence, as the purpose for sentencing is to reform a convicted person. It is right that the sentence must deal with the offense and the offender proportionately. In the circumstances of the matter, the outcome of the case in question, which is the electoral petition number 1 of 2019, was not affected at all by the matters arising in this particular case. And we therefore, my lady, humbly pray and plead for the court's mercy in sentencing the defendant, and we do pray that the provisions of Section 340 and 339 of the Criminal Procedure and Evidence Code be invoked. My lady, we wonder whether probably on the facts that we have raised in mitigation, it shall be required of the defendant to actually confirm the facts under oath, as he will be able to do so. That would be all, my lady.
Thank you so much, my lady. In response, my lady, the state will respond to the issues that have been raised by the defense in mitigation, and also raise others that may not have been touched on by the defense. First and foremost, my lady, the defense talks of the uprightness of the defendant, now a convict, as regards his personality. My lord, the offense the offenses which he committed completely eroded this uprightness, so it should not even be raised. He is not an upright man, and that's a fact. Secondly, my lady, we've been told that the convict is a family man with children, that he has a business, that he helps a number of less privileged people within our society. My lady, the convict should have known that when he voluntarily and happily embarked on this criminal journey. We look up to the elderly as wiser. We are told he's 60 years old. He ought to have known this, that by doing what he did, a number of people, including his family members, will be affected. So that should not influence this court. Thirdly, my lady, the defense says the offenses which the convict wanted to commit or committed did not affect the result of the elections case. And again, my lady, that should not influence you when it comes to sentencing the convict. I don't want to imagine what could have happened if he had succeeded. When we look back, my lady, at the environment that existed in this country, the tension that was there during the elections case, I'm sorry to say this, my lady, but the fact that the judges decided to remain faithful to their judicial oath by refusing the bribe from the convict helped this country to avoid bloodshed, chaos. And that could have happened if the accused person, the convict, had succeeded. This court should be reminded of the environment which was there that time, my lady. What the convict wanted to do, the offense which he had committed, is a very serious offense, my lady. He wanted to defeat the cause of justice. in one of the most high profile, if not the most high profile case in this country ever, the elections case. The country was at a standstill. There was division in this country. The convict wanted to use his wealth, power, and influence, my lady, to manipulate the justice system, and that should not be tolerated at all. Let the convict serve as a warning and a stark reminder to the rich, the powerful, and influential that their wealth, power, and influence will not always get them what they want. We have a law in this country which has to be complied by every Malawian, including the convict. On the issue of remorse, my lady, it is surprising that the defense have the courage to tell you, my lady, that the convict is remorseful. He is not. From the word go, when the Anti-Corruption Bureau arrested the convict, the machinations started that time to defeat the cause of justice. I would not want to remind this court about the nocturnal machinations with respect to the cancellation of the bail of the arrest that the ACB had made on the convict. My lady, we have been to the High Court before Justice Jack Nliva. We have been to the Supreme Court before Justice Edward Tweya, where 3 applications were made. In your court, my lady, several applications were made by the convict, one of them attempting to have you removed or remove yourself from this case, which we vehemently opposed, and you agreed, my lady, and thank you so much for that. He made an accusation against you and Justice Kalembera. He has made accusations, several of them, against 7 judges of the High Court. Now, to talk of remorse on the part of the convict, it's unbelievable. If I have to agree with them that the word remorse exists, I would say that is imaginary remorse, my lady. He told this court, fifthly, my lady, that he runs a trust, or there is a trust, TFM. His businesses, including the bank, my lady, he told this court, the convict himself, that he is no longer the CEO of FTH Bank or the managing director. It is his son, William Mpinganjira. He is no longer actively running the businesses. He told us he is now into charitable work. The trust has separate trustees that run the trust. The bank was listed, the Malawi Stock Exchange. The point I'm putting across, my lady, is these institutions, including the bank, have been running with him not being the managing director. So the issue of employees losing their job, other people suffering, does not or do not arise. The trust is a separate legal personality, Melody. When he decided to retire from the businesses, I remember we asked him in cross-examination. He said it was in relation to this case, which you also referred to in your judgment, Melody. These entities will run without him. They have run without him from the time he retired. I will not talk about Wanderers Football Club. I've seen their supporters around. Not that I fear them, but this was an afterthought. It's only 2 months ago when he decided to sponsor that football team. So that's not an issue before this court, and should not convince you otherwise, my lady. There's a talk of his medical condition. We haven't been furnished with a medical report to that effect. So much as I do not dispute, because I do not know, what I would say to this court is there is no proof that he is in bad health. If the defense will furnish us with that proof, well and good, you may consider that, my lady. Last but one, something touching on the issue of remorse. You might recall, my lady, there was a request that was made from the defense on plea bargaining. It came from them, not us. It failed. All in all, the conduct of the convict, my lady, has wasted the court's time and our time as well as the state. We have spent resources, including financial resources, on this case. If indeed he was remorseful, he could have taken advantage of the very first opportunity he had to plead guilty. Did he? No, he did not. He had to go through full trial. So the issue of remorse should not arise now after being convicted. He wasn't remorse, he's not remorseful up to this day. The defense has referred this court to section 339 of the Criminal Procedure and Evidence Code, my lady, which makes provision for suspended sentence. This provision, my lady, is not applicable in this case and should not be applied. When you read subsection 2 of that section, my lady, it says, where a person is convicted of any offense, not being an offense, the sentence for which is fixed by law. I'll stop there and underline the words, not fixed by law. When you go to the Corrupt Practices Act, the offenses which we charged the convict, which you have rightly convicted him for, sections 24 subsection 2, sections 25 25A subsection 2 and section 25B subsection 2 or 3 of the Corrupt Practices Act, the sentence is fixed by law. And I'll read it. Section 34 of the Corrupt Practices Act. Any person who is guilty of an offense under this part, and this is the part which contains offenses under the Corrupt Practices Act, Part 4, shall be liable to imprisonment for 12 years. So the sentence is fixed, 12 years. Therefore, Section 339, my lady, is not applicable. This court should not impose a suspended sentence on the convict. And the 12 years, my lady, goes to show the seriousness of these offenses. We therefore humbly request this honorable court, my lady, to invoke a custodial sentence on the convict and not a suspended sentence. A custodial sentence that will reflect the seriousness of the offenses he committed. A sentence that will remind the rest of us that defeating the cause of justice shall not be tolerated in this country, my lady. We pray. Thank you so much, my lady. Thank you.
Thank you. Right.
My lady, I would like to respond to reply to the address by Learned Solicitor General, and to say, in respect of the fixing of sentences, the sentencing under the Corrupt Practices Act is not fixed. The mention of the 12 years under that act is not a fixing of the sentence. The court still has discretion to decide how long the sentence shall be up to the 12 years. When the law fixes a sentence, that discretion does not exist for the court. An example of a fixing of a sentence, my lady, is section 283, subsection 4 of the Penal Code, in respect of theft by public servant. Where the provision says the punishment shall be imprisonment for a minimum term of 2 years and a maximum imprisonment of life. That means, my lady, the court does not have discretion to sentence lower than 2 years, as an example. A good example was also provided, my lady, under the same Section 283 before it was repealed into the form it is now. So when a law fixes, discretion is taken away from the court. In this case, my lady, the court has discretion. That is not a fixing. Therefore, Section 339 and 340 of the Criminal Procedure and Evidence Code still applies. Already the facts in mitigation that have been offered to the court have been stated as a matter of fact. And which my learned friend, my colleague Mr. Chokoto, has indicated are subject to confirmation under oath by the defendant. And my lady, the request was made that you may consider allowing Dr. Mpinganjira to confirm those facts on oath. And my lady, we repeat that request. I don't think, my lady, I don't think it is correct for my learned friend, learned Solicitor General, to want to play down the effect of age, because it is a fact. And it has always been the policy of the court to exercise leniency with respect to age, with respect to old age. Now, Learned Solicitor General says that Dr. Mpinganjira should have known of his responsibilities, and therefore he should not mention them here. But let him, knowing your responsibilities, and committing an offense regardless, does not take away from those responsibilities. Those responsibilities exist. To the issue about uprightness, my colleague Mr. Chokoto said, my lady, and I would like to emphasize that is uprightness mentioned by reference to all the 60 years that the defendant has stayed on this earth without having any brush with the law. That's what my learned colleague, Mr. Chokoto, referred to. Regarding medical condition, my lady, it is on record regarding the COVID-19 situation that Dr. Mpinganjira has had to deal with while the proceedings continued in this case.
Attempted to play the court against the accused. He didn't.
And my lady, I would also like to mention that a plea of not guilty has never been a reason for passing a higher sentence. Even though a plea of guilty is a mitigating factor. So in other words, the opposite is not true. So courts do not punish people for not pleading guilty. That is what learned Solicitor General is suggesting. Further, my lady, the defendant should not be seen in negative light by this court because he sought to use rights that the law provides to him. So the fact of making applications before the court should not be used against him because the law provides for those. By the same token, my lady, the fact that plea bargaining did not work should not be used against the defendant, because whether or not the case ends at plea bargaining stage is subject of the exercise of rights. And the exercise of a right, my lady, should never be visited against a citizen or any person appearing before the court. The work of the foundation, my lady, that the defendant is involved in has been mentioned by reference, my lady, to the work that he is doing personally. And that, my lady, he is prepared to confirm to the court under oath. And my lady, the manner in which the offenses that you have convicted for were committed is not the most brazen that your court will have to deal with. There was no arrogance about it. In fact, my lady, as you find in your judgment, you do so as a matter of interpretation of the evidence. So you do not, my lady, have a brazen commission of the offense, an arrogant, brazen commission of offenses. And that, my lady, should tell in favor of the defendant.
Yeah, I was mentioning the issue of the complaints to the ACP.
You should wind up if you want him to give
Yes, my lady.
information.
Learned Solicitor General also tries almost emotively, my lady, unfortunately.
That is unacceptable, my lady. I did not. The fact that I was emphasizing a point doesn't mean I was emotional. Can he continue with the substantive
My lady.
points in his mitigation? Thank you, my lady.
I said emotively, not emotionally. And I'll say why, my lady.
Withdraw that and state what you want to state.
Yes, my lady. I'm talking about an emotive attempt to try and
You
play.
should draw the word emotive and state what you want to state.
My lady, I'm talking
You are
about.
not arguing about the case anymore. This is about a sentence, and it's not about you. It's about him.
My lady, the point I'm trying to make to the court is in relation to reports being made to the ACB. The Corrupt Practices Act requires a report being made to the ACB. Whenever circumstances arise in that respect. Not every report made to the ACB will be found to have been made out by the person who reports it. And where the ACB finds that a report.
My lady, the defense indicated that they wanted to respond to the issues that I had raised. I did not touch on that. So what is he responding to? He's making a fresh submission on that. Thank you.
This is submission in mitigation of sentence. Let me not repeat that again. Okay? This is not making a case whether he's guilty or not.
My lady.
He is guilty. This is submission in mitigation of the possible sentence this court can pass. Now can we get on with it, please?
My lady, Learned Solicitor General referred your ladyship to a report made by the defendant that relates to yourself. And the question is always going to be whether or not it is made out, did he have a right to make the comment, to make the report? My lady, when the law provides for such a right, it should not be used against a person appearing in your court. That is the point that I'm trying to make, my lady. So on the whole, my lady, we pray that the court exercises leniency on the basis of those mitigating factors. That would be all, my lady. Thank you.
And what do you want the accused person to confirm?
My lady, there were issues of fact that my colleague, Mr. Chokoto, put before the court in respect of the issues that the defendant is involved in. So that's statement made from the bar in respect of all those issues, and we were requesting that you could ask Dr. Mpinganjira to just confirm those questions of fact to the court under oath in order to complete the picture, rather than them only being a statement from the bar. That was the request, my lady. Thank you, my lady.
Mr. Amos, can you take an oath and confirm?
Are you going to do that? Do you read the board? Yes. Raise your right hand and repeat after me. I swear by the Almighty God.
I swear by the Almighty God
That whatever I shall confirm in this court.
That whatever I shall confirm in this court
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing.
And nothing
but the truth.
But the truth.
Thank you.
Thank you, Dr. Mpinganjira. My colleague, Mr. Chokoto, put before the court issues of fact touching on your age, touching on physical health, touching on the work that you do with the Thompson and Barbara Mpinganjira Foundation, touching on your family situations, your family relations. What else? What else?
Yeah, I think that's it.
Are you able to confirm to this court, Dr. Mpinganjira, those facts that Mr. Chokoto laid before the court?
Yes, I confirm.
That'll be my letter. Thank you.
Do you have any question?
My lady. Dr. Mpinganjira, can you confirm that you have not brought any evidence in this court to prove all the things that you have confirmed? Documentation that you are sick.
I can confirm. I can confirm.
You don't have them here. All right. That will be all, my lady.
My lady, I don't wish to re-examine on that. It is a matter of record, the COVID situation. It's on the court record. So I'll say nothing else.
Thank you.
Thank you, my lady.
Right, we adjourn. As I had said, your bail is revoked. You will stay at Chichiri prison until the sentence is delivered. We stand adjourned until then.
Mweneutu unali wondamatiki Dr. Thompson Mpinganjira amayankha okhudza kuti ankafuna kunyengerera majaji amwe ankava mlandu wa mtsogoleri wa chisankho cha mtsogoleri wa dziko lino mu 2019. Tinamva kuchokera kwa lawyer wa Mpinganjira omwe amaperekatu mfundo zosiyanasiyana zokhudza kuti Mpinganjira asawapatse chigamulo choti akakhale kukaseweza jele, pomwe pano awapeza kuti ndiolakwa pa milandu yosiyanasiyana iwiri mwa 6 yomwe amayankha. Pano ndili ndi mzanga Madalitso Phiri, umatsatira mlandu uja, tangotipatsa chithunzithunzi makamaka akambanje ajaji popereka chigamulo
chabwino zikomo kwambiri Alex. Ajaji Gabriel inali chigamulo chimene anachipereka mu pafupifupi maola awiri, koma tingonena mwammangu mwina fundo zikuluziku zimene anafotokoza. Nkhani ndionena kuti monga ukudziwa kuti Mpinganjira amadzudzula kapena kuti amapanga accuse kuti angafuna kunyengerera majaji chankamva mlandu wa chisankho. Ndiye mlandu umenewu akuti angafuna kunyengerera makamaka justice anaimbira koyambirira Justice Michael Tembo, kenako Justice Potana amene anali ngati mkulu wa judge amene amamva mlandu umenewu. Ndiye pofotokoza mu umboni wonse umene wakhala kuperekedwa ndi zina zotero nalizonena kuti malingana ndi umboni Judge Gabriel kuti malingana ndi umboni umene unabwera mbwaloli panali nkhani ija yokhudzana ndi kuti popereka umboni angakambapo za kuti panali pasero ina yake yokuti afuna apatse pasero. Ndi Mpinganjira ananena kuti popereka umboni wawo ananena kuti pasero imeneyo panalibe. Ankanena za pasero kuti Justice Tembo apatse nambala yokuti ayankhulane ndi Justice Potani. Ndiye koma judge anena kuti zikuoneka kuti pasero inalipo malinga ndi umboni umene unaperekedwa. Amanena za ma transcripts, ukumbukira bwino kuti
panali kukambirana pa WhatsApp komanso pa phone. Zimene zinachitika ndicho kuti sizinkafika bwino kuti anakapanga ma transcripts kuti kodi amayankhulana kuti chani. Zimene zikusonyeza poyera kuti judge makamaka Mpinganjira ankayankhulana ndi Justice Tembo, komanso amafuna kuti anyengerere majaji amene achifukwa chinanso chimene amanena choti ine ndakhala ndopereka ndalama kwa zipani zonse kaya ndatsogolera zipani osiyanasiyana. Koma Judge Gabriel akunena kuti ndi umboni umene unaperekedwa kuoneka kuti iwowo kwambiri Mpinganjira kuoneka kuti amatsamira mbali ya DPP chifukwa ndalama zimene amapereka ku DPP zambiri pafupi 940 chakuti million kusiyana ndi ndalama zimene amapereka ku Ndiye mwachidule tikumva zoti bwalo lino la gamulatu Dr. Thompson Mpinganjira kuti achoke kaye padakali pano, asakhalenso panja, asakhale mfulu, akayasungidwe ku Chichili prison, komanso iwowa apezeka olakwa pofuna kunyengerera majaji omwe ankava mlandu umenewu.
Ndi zimenezo zimene anena bwalo kuti akasunge kale ku Chichili, sanafotokoze kuti adzawagamula liti, kuti chilango chake chikhala chotani. Chimene timaona mbwalomu ndi maloya awo kunena kuti munthu ngakhale pampeza olakwa koma ndi wachikulire, ali ndi zaka zoposa 60 mwazina, amathandiza anthu ambiri, amathandizaso ali ndi zidzukulu mwazina. Ndiye kuti mugamule mpase chilango choti akakhale kundende anthu ambiri avutika. Komanso lawyer wa SB Solicitor General Mademba Matiya mulandu apala mulandu waukulu ndofunika kuti akakhale kundende kuti anthu ena atengerepo chitsanzo kuti osagulitsa ndalama ndi mphamvu udyo.
Now that's what has transpired at the Blantyre Legislature at the High Court, where the court has found business mogul Dr. Thompson Mpinganjira guilty of 2 out of the 6 counts pertaining to attempting to induce the 5 constitutional judges that had the presidential elections case. Briefly, could you confirm that, and where is...
Yeah, very briefly, I can confirm that Justice Gabriel has indeed convicted Dr. Mpinganjira on 2 of the 6 counts he was answering. She says the evidence presented in court is convincing enough to see the motive that was behind Dr. Mpinganjira's move towards the judges that had the presidential...
This is from the evidence, from the transcripts.
From the transcripts and all the evidence that was presented in court. So in short, he has revoked his bail.
he will be at Chichiri prison pending sentencing. We heard both sides, his lawyers arguing that the sentence should not be a custodial one. It should be a suspended sentence because he is old, he's sick, and the like.
Now, there was an issue to do with wealth, power, and influence. That's a mitigating factor is pushed aside.
Okay, it was the Solicitor General was saying his power, because he is wealth and power, people should not abuse their power and wealth. That was the point.
Now, that's what has transpired here at the Blantyre Registry High Court. From me, Alex Banda, we have to hand you over back to Area 47, Sector 5 for further transmission.